but not live. I literally just finished the live stream from day 2 of Steve Bannon's trial. And I didn't look at my phone the entire stream to know that Joe Nierman, the boots on the ground in DC, had texted me wanting to get in. So I said, we're just going to shoot this segment live between the two of us, and I'm going to post it as a separate video after so that all of you can hear directly from Joe Nierman. Good Lawgic, the way you think a New Yorker would say Lawgic, Lawgic. Joe, sir, first of all, I'm sorry I didn't see the text. It would have been great to have you in live, but let's just do it now. What happened today?
So it didn't start the way we anticipated the day was going to start. We were led to believe that there was going to be a back room trimming, use of peremptory challenges, 3 apiece for the government and the defense, because they had whittled down their pool of 60 to 22. So they want to get down to 12 plus 2 alternates. So they were going to do that by basically knocking off 3 apiece, which would put them at 16, and then from the alternates they would each knock off 1 apiece. And then we thought they were just going to go right into jury instructions and opening statements, but that's not at all what happened this morning. Instead, there was a lengthy debate with respect to various letters that the government wanted to have admitted in order to support their case in chief. And the defense was upset in the sense that there was reference to the executive privilege, and they were saying, we're not supposed to be talking about executive privilege. Now there's going to be all this reference in these letters to executive privilege, and we can't even talk about it. So it looks as if he's disingenuous. I think that's what Schoen was basically trying to argue. It's like, if we're not talking about executive privilege, and then they see all these things about executive privilege, then he looks like in these letters like he's full of crap when he's raising this executive privilege, and we're restricted from being able to explain it. So it makes us look terrible. And the judge responded to him.
Let me ask you one thing. Wait, but before you go on, the letters at issue, this is correspondence between the committee itself and Bannon's attorneys about the subpoenas, about the executive privilege, and about what else? About accommodating for the deposition?
So there were multiple letters that were sent by Robert Costello, that's Bannon's former attorney. He was the one who accepted service of the subpoena on Bannon's behalf, and sent letters. I think in early October, there was at least 2 letters that were sent before the deposition date. So let's bear in mind there was a date for production documents, which was October 7, 2021, and then there was an appearance for a deposition, which was a week later, on October 14th. All this was sent out on September 23rd. So he had 2 weeks to get together his documents, and then a week later he was supposed to come in for deposition. So even before the documents were supposed to be submitted, there was a letter from Robert Costello, which, according to the government, he alleges that he's not obligated to come in because of executive privilege. I believe it's likely that there was also some question from him as to the legitimacy of the committee altogether, only because. And I'm saying that without having a copy of the letter in front of me. I was sitting in court all day. But my recollection is, and I know that they certainly brought motions to the fact that they should be able to raise a defense that this is not a legitimate committee, because Bannon claims that in order for the committee to be constitutional, it has to have 13 members, and this committee only has 8. And accordingly, if they're an unconstitutional committee, they wouldn't, by his argument, have the power to issue a valid subpoena or an enforceable subpoena. So those were the bases that he's been setting forth as to why it is that he wasn't going to come in. Now, the executive privilege is an interesting thing, because it's a matter of, it could be interpreted as a matter of, it's not just that I can rely on executive privilege, it's that I'm prohibited from coming in. And if that's his state of mind, and this is basically what the court was talking about, was you cannot, and this is what was really very confusing to both sets of attorneys, in that the judge said, I didn't tell you you're restricted altogether from bringing up executive privilege. If he were to make a proffer, and he said, I'm not suggesting that he will, but if he were to make a proffer, that based on the executive privilege, that led to a mistake of fact, well, that is something he could assert.
Proffer, for those who don't understand what it means?
A proffer is basically an offer of an explanation of what his defense is. So, look, I'm not a criminal defense attorney, but that's given context. I don't know if that's the technical definition, but given context, it seemed pretty clear what the judge was suggesting. It could be there's a more accurate technical definition.
I heard them use that term as well. But one question I had, Joe, if you know the answer, the prosecution brings up these letters and says, we're going to invoke them as evidence, or we intend on bringing them in as evidence. It's not the first time they've been disclosed to Bannon's team, correct? Like Bannon already has these letters. They know that the prosecution might rely on them for the prosecution.
Well, he actually has, if you think about it, his lawyer sent the letter. He had it before even the committee ever received it, right? I mean, he has these letters. It's a matter, there was correspondence back and forth. Now, the correspondence was with a woman who was acting, she's an attorney who acts as she's the general counsel for the committee by the name of Kirsten Amberling. She ended up being the first witness that we heard from today. And so it was communication basically between Amberling and Costello as to what was going to happen with this entire process. So the arguments that were happening, and this is an important point for your audience to understand, that you can rely on a mistake of fact as a valid defense, but not a mistake of law. And the distinction could be very perplexing to most lay people and even to most attorneys as to when you're in a situation that it's a mistake of law versus a mistake of fact. And the best way I can give you an analogy that I think would be a fair way of drawing it up is if you picture someone driving 70 miles an hour in a 45-mile-an-hour zone, you cannot say, well, I thought that this was a 75-mile-an-hour zone. Even if you really thought that, even if you 100% really believe that and you're wrong, that's not a valid defense. You still are found guilty of that. But let's say instead of saying that, you say, look, I built this car from scratch. It doesn't have a speedometer, but every time I measured it, it had a maximum speed of 45 miles an hour. So I figured that there's no way on earth I could be going faster than 45. And it turns out I was going 75. That's a mistake on the fact, not a mistake on the law. And that's something that theoretically could be feasible. I'm not saying those of you who are car manufacturers, I'm not saying that's accurate.
No,
I'll give you an example.
There's a number of problems with the analogy, but I think we got the idea, at the very least, the nuance. But
Yeah.
Joe, my question is this. Did the prosecution not already disclose, and had they not planned for what evidence the prosecution would want to admit? So that I don't understand why they're having this debate about these letters.
So I think what led to this whole issue was the fact that last week on Thursday, there was a ruling from the judge which cut off the legs of him being able to make this claim of executive privilege. And that's what made get so upset that he's like, they're going to be introducing these letters talking about executive privilege, and we can't talk back about it. And I think he felt it made it look like that Bannon was acting in bad faith in the letters. And if he's not going to be able to discuss the context of it at all. And the judge says, that's not true. What I told you on Thursday was that you could raise it if he proffers certain, if he were to make a proffer, it's something to the effect of that his belief in the executive privilege led him to think that there would be accommodations made for him and that the date was not fixed. And this became a big focal point, that if he had a mistake as to whether the subpoena was really a firm date or it was a date that was initially intended, but that he anticipated, or he would say it was customary, that whenever you're dealing with someone who's been so tightly linked with the president of the United States, that accommodations are made for them. So and that's been his experience in other similar settings, that could lead to a mistake of fact defense, which would be available to him, which is related to the whole executive privilege thing, even though it's not really saying I'm relying on the executive privilege. And he was saying that, it's not that you're precluded altogether from talking about executive privilege. But he did recognize that this would require redaction of these letters in certain ways. And he was suggesting maybe that's the best way to resolve this, if we just redact certain paragraphs. And he started trying to...
The judge said, let's redact certain paragraphs.
Yeah, that's what he was
Okay.
suggesting. Maybe this is the best way to split the baby is by literally splitting the baby and redacting certain parts of it, and thereby it won't be so bad for it won't look so bad for him or whatever. And what he ended up, and he couldn't figure out himself how to do it. So he's like, so he was very what we would say mbulbul about this whole thing. That's what my people would say. There's a lot of confusion that was happening here, and just to show you how much confusion there was, and even with respect to strategy, like what strategy is best for each party. The government.
Hold on. Before you get to the strategy, actually, just let's spoil the punchline. What ultimately was adjudicated upon as relates to the admissibility of these correspondence in their entirety, unredacted?
In the end, Schoen and the defense said, you know what? Put the whole letter in. It's
Of course.
fine by us.
Of course, it should be fine by the defense and it should be fine by the prosecution. Okay, all the letters unredacted about alleging executive privilege. The committee saying no, you don't benefit from it. They're going in. Jury's going to see them, and obviously Bannon can now not only testify on them, but he can cross-examine on them.
Right.
Yeah, go for it.
Yeah, no, and I think that's correct. And it was such a convoluted back and forth as to what was happening there, and there was even so much confusion. There was one point the judge started yelling at Vaughn, who's the attorney for the government, and because she said at a certain point this morning that should be totally fine with Bannon testifying that the reason he didn't come into court, he didn't come into deposition, was because his attorney told him not to go. Because she said that will basically show that his decision not to come was willful. And I think she also said it'll also imply that it was willful based on a mistake of law, and now you're guilty because your lawyer might have told you the law incorrectly, but you're now relying on the mistake of law, and you're guilty. When the judge heard this, he went nuts. He started yelling at her, saying one of the first motions that was brought to me by the government was that there should be no testimony at all that he was relying on his attorney. And now you're doing about face here, telling me that that should be admissible in. And she said, no. What we meant was that he should not be able to rely on that as a defense, but there certainly should be testimony allowed on that. And he said, poppycock, without using that word or any offensive word. But he goes, no, that is not true at all. You specifically said you wanted no testimony on this at all, and now you're trying to switch up everything here. And she started dancing around as to what she meant.
Let her do it. I think it's bad for the prosecution. The judge, if she wants to undo the favorable ruling, that's on the prosecution. But the judge, so it was in fact the prosecution that made an initial motion to basically ban Bannon from invoking executive privilege. It was at their request that was even heard by the judge.
Yeah, but I believe that was their request, that they to basically cut the legs off of as many defenses as possible. And you can understand that because basically what's executive privilege? You're saying that I thought the law was that I couldn't come, but that's a mistake on law. You're guilty. So that's why she's like, I don't want the jury to think that they can hang their hat on that as a basis to find him not guilty. Yeah. So that's why they don't want any discussion about it at all. And you can easily see how a jury will get so quickly confused about this, and for them to say, well, yeah, he didn't know. How are we going to throw him in jail if he didn't know?
I wouldn't wait on that from a DC jury. I would say, yeah, of course he didn't have executive privilege and whatever. Okay, so that's fantastic. So the judge then gets mad at her and says, look, I ruled on this at your request, and now what you're asking to do is basically not bypass, but rather just set aside my court ruling. Despite all of the pleadings as to why it was necessary in the first place, you're making me look like an idiot, prosecution, and ultimately they're going to get in the letters.
And what he also did was he got mad at Schoen. He's like, "You saying that I'm changing my ruling today as from what I said on Thursday?" And he took a 10-minute recess, pulled the transcript, and read from the section there where he told them that there could be ways, and depending on how the defense strategizes, there could be situations where executive privilege could be referenced. And essentially what he's saying is if this mistake of law led to a mistake of fact, or basically something to that effect, And then you had the mistake of fact, and it's a way to sort of almost backdoor the executive privilege in here. And it was almost like he was like, don't start telling me that I'm changing up here. I'm not changing up here. Don't start claiming that this is 11th hour change. This is prejudicial to you. Well, Corcoran steps in and he's like, Your Honor, there's so many moving parts here. Can we get a continuance for 30 days so we can sort this out in order not to waste the time, the investment of time we had yesterday?
To which the judge undoubtedly says, look, we've already got jury members here. We've got 16 that have been sitting all morning. We're not putting this off another month. We're moving.
Right. Well, we didn't actually trim it yet. At this point, we hadn't yet trimmed it. But yeah, so then anyway, the judge ended up denying it while saying he might consider pushing it off to Monday just to let everyone get their ducks in a row. But that became moot. He said, why don't you guys try sorting out the letter and then we'll see where we're at 1 o'clock. But it became moot when the defense said there's nothing to sort out. We're fine with the letter coming in. And he said, great. Let's do our peremptories and trim it down. So they took turns.
Oh yeah, turns. Cut to the chase of that. The letters are in. They then whittle down the jury to 14, 9 men, 5 women. And then they started opening arguments at 1 o'clock.
No. They started. They did the jury whittling around 1:15, 1:30, and then he took a break for like 10 minutes, brought the jury in, had a lengthy instruction to give them about what they were restricted from doing while they're impaneled, and swore them in, and basically then took another break, and we had opening arguments starting around 3 o'clock, as I recall.
Oh wow, okay. And then only one. Oh yeah, sorry. Go ahead.
Those each lasted roughly 15 minutes or so.
Okay, and I presume if we recap, it's going to be prosecution says cut and dry. He received it. He invoked executive. Or did they talk about executive privilege in opening arguments?
She made the mistake of referencing that, and then in defense's opening statement, he said, "Look, I'll say the term because my adversary said it. That there was talk about executive privilege. It's almost like they don't even know what they're allowed to say, what they're not allowed to say." It's kind of funny to watch them fumble around, but if the closing point that each of them made was she made the point for the government that when you finish with this trial, you might think to yourself, this is a pretty simple thing. He served a subpoena and he tried snubbing his nose at the government, saying, "I don't have to listen to you," and now he needs to be punished for that. And if that's what you think at the end of the trial, you're right. That's all this is. This whole big thing is simply one man deciding that he doesn't have to listen to what the government tells him. And that's why we're going to expect that you're going to find him guilty. And then she sat down, and his thing was basically saying everything that they just told you is not accurate, in the sense that she's described him as ignoring the subpoenas. He did anything but. His attorney was sending letters. He was expecting that this whole thing was going to get resolved. And his final message was an interesting point. He said, every document that comes before you, I'm going to ask you to just have one question burning on your minds as every piece of evidence is brought before you. And that is, was this document created purely because of politics? And that was an interesting thing to just sort of leave them to sort of to basically pound home how this is all about politics. So,
oh yeah, I bet the jury will agree. It is about politics, as will be the conviction.
Yes,
and now they've only had one witness start, and it's Amberling, the lawyer for the committee.
Correct.
Okay.
Correct. It was a very boring hour and a quarter of testimony where she basically explains what the House Select Committee is, how it was formed, what its purpose was. Every time she mentions January 6th, you picture it's like half the globe fell off its axis and all the billions of people who died, and that it was the worst travesty in human history if you hear her talk about it. She talks about the several dead cops. I was just like, I don't know. And that is what it says in the House resolution. They reference that there were several dead police officers.
An act of domestic terrorism over and over and over again. It's preposterous.
And she is basically she is Miss January 6th. Like, that is her whole deal. Like, she's basically the one overseeing the entire staff. Because what you have to recognize, and this is something she explained to the jury, that sitting on there is your 8 members of the House of Representatives, but there's also a staff of countless unelected people who are supposed to help them reach decisions, understand things, do investigation, do research, who have nothing to do with ever being elected, and that she's been serving in that capacity for a couple of decades now in various committees, and for the last year, she's been the one overseeing the House Select Committee for January 6th. And they also paint this entire committee in order to sort of make it sound less political, I believe. And that's perhaps my cynicism, but that she paints it as that in order for Congress to enact laws that are going to benefit our country, they need to be able to do research and oversight. And this is basically an exploration to figure out what reforms may be necessary to ensure that we don't have a travesty like this all over again. And with respect to election reform, or with respect to, I don't even know. But basically,
to that I will say poppycock.
Yeah, I mean, I'm with you, but that's what we need to know with the other side, how they're.
We talked about it yesterday.
What dressing they're putting on it.
Yeah, they need to know. It's an inquiry to determine what future legislation is going to be required. That's in the resolution. It's a superficial, shallow pretext. Joe, thank you. I mean, that's fantastic. Pleasure. And now I just got the notification that Robert Gouveia is live, so I think you're going to be appearing there. Joe, where can people find you?
So I'm at Good Lawgic on YouTube. That's where most people see me. I do a nightly stream, and while I'm covering this trial, I give a much lengthier, detailed breakdown as moment by moment as to what happened in the trial, and a couple of celebrity sightings that I have, and those interactions. And I also weigh in with since I'm a New York attorney, I've been practicing litigation for 2 decades now. So I break down law and politics there, and I urge you guys check me up. And if you want to get updates on this case, I try and drop them at lunch for one reason or another. YouTube has been really horrendous on upload time. I have a video that I put up 5 hours ago that they say is going to finally be finished process in 30 minutes. So it's very, very painful. But if you want more information or notice, I urge you, subscribe, hit the bell, and that way you'll know when I'll drop. I'm there every day. I'm covering this trial. Right, and the reason I think one thing I want to stress is the reason this case is so important is because whether you like Bannon or you hate Bannon, you think he's evil, at the end of the day, what we have here is a Congress that's controlled by one party and an executive branch that's controlled by the same party. And they're basically trying to do everything they can in this investigation, this hearing, this committee hearing, to basically show how evil the other party is. And not simply that, but to make them bend the knee and appear and say that if you don't appear for this thing, which cannot have any sort of justice come out of it because they don't have any authority to actually imprison anyone or do anything as a result of this hearing. But if you don't come to this trial, which anyone on the other side looks at as a show trial, we have the right to imprison you. We have the right to throw you in jail. And that all to quote unquote preserve the safety of our democratic republic. And if you think about it, they might be saving a republic, but if these are the methods you're enacting, that you're basically punishing your adversaries criminally because they're not willing to bend the knee at a show trial, you have to ask yourself, maybe you're saving the republic, but I don't know if it's a democratic republic anymore. And that's a very disconcerting thing, no matter which side of the aisle you're on. So,
fantastic, Joe. Thank you very much. I'm going to end this, and I'll see you in a bit. Thank you.